Good evening, ladies and gentlemen. Well, if you had been interested in rhetoric, you would have stayed home and watched the lead-up to the Democratic nomination. So I'm going to plunge straight into substance. I expect that's why you braved the rain this evening. In the 20 years between 1980 and 2000, according to the United Nations Human Development Report, 81 countries took significant steps towards democratization. Yet, according to the same report, half of those countries are not full democracies. They suffer from shallow political participation, they are dominated by one party, or they allow very limited political competition. So, take a look at the big picture. 2 decades ago, 1/3 of the world's states were democracies. Now, a generation later, 2/3 are democracies. That is something to celebrate. But when we look closely, we find that democracy has not taken deep root. Indeed, several countries are moving backwards. Recent events in Russia, for instance, have led several commentators to proclaim it once again a wasteland of democracy. Many other countries are re-establishing so-called soft authoritarian regimes, regimes that have the trappings of democracy but none of its substance. We must not fool ourselves that this applies only to poor countries. Highly developed countries such as Italy are showing themselves susceptible to undemocratic media rules and manipulation. So we find that there has been an unprecedented wave of democracy, and simultaneously there is a crisis of democratic quality and sustainability. The other part of the big picture I think we should look at tonight is the impact of the war on terror on democracy. Certainly drastic action is needed against the new security threats of our time. The Bush administration argues that current international apparatuses such as the UN are often slow and ineffective. Unilateral action, or at least action by a coalition of the willing, is sometimes necessary in their view. The administration is also opposed to any review of US actions by, for instance, an international criminal court. Whether you agree or disagree strongly with this, the threat of terrorism raises a deep tension, one we must confront, one that is intrinsic to international law itself. On the one hand, there is the content of law. It must demonstrate the right kinds of respect for all persons in the right ways. It must be good law. On the other hand, there is the application of law. The rule of law is vindicated by apprehending, prosecuting, and punishing perpetrators and wrongdoers. The great challenge is that catching and convicting terrorists and other rogues may require methods that good law normally prohibits. And the great concern is that regimes around the world are using the pretext of the war on terror to violate civil liberties and the principles of democracy at home, in the United States, and elsewhere, and abroad. Put all this together, and I think we have cause for worry. There seems to be a crisis in international law, a crisis in democracy, and they are connected. What is to be done? I am sure that many of you, like me, are frustrated by seeing endless complaints in the media, the New York Times, etc., and too few positive proposals about how to get things right, get things on track. I'm also frustrated by some of the positive proposals, the few that there are, out there. For instance, so-called liberal imperialists want to have America impose its will along with democracy on recalcitrant leaders and local populations. Such liberal imperialists have proclaimed the empire of liberty. Well, as a South African, I am somewhat suspicious of this view. I can testify personally it doesn't really work, and that there are few things more dangerous and ineffective than the old Latin maxim, oderint dum metuant. Let them hate us so long as they fear us. Don't get me wrong, Power and military force are important for abolishing dictatorships, and America must play a leading role. But democracy will only take root, and remember that is the problem, if democratic institutions and practices are created in large parts by local populations, local communities. And they invariably need the support of a variety of international actors who invariably need the support of a range of agreed laws and norms. It was these frustrations that led us to set up at the Carnegie Council the Empire and Democracy Project. Specifically, we are focusing on international mechanisms for promoting democracy around the world. By identifying clear and actionable alternatives to empire, we hope to contribute something to counteract the new tides of militarism and militancy that threaten to engulf global security and global democracy. Before I turn to tonight's speakers, let me mention just one finding of the project that I think you will find very interesting. And that is that there is a powerful relationship between socioeconomic level and democratic survival and success. If you look at the history, a country that has an over $6,000 GDP per capita, that is per citizen, has statistically no chance of collapsing if it is a democracy. The democratic institutions are safe and in place. But in a very poor country, there is statistically a 1 in 8 chance of democracy collapsing every year. Think about that. 12% chance of your political system collapsing every year. Poor countries struggle to save democracy and improve democracy, partly because the political system and its functionaries, such as judges and representatives, are more easily tempted and sometimes bought by wealthy and powerful interests, sometimes business interests. This is one place where international law surely comes in. Since business interests, for example, are often based in developed countries such as the United States and France, international law and conventions such as those against bribery, backed by real enforcement, are indispensable for reducing such democracy-undermining abuses. Again, we see that democracy is not just a concern for developing countries, and that the problems are not simply caused by those internal to developing countries. These findings have obvious implications for Iraq and Afghanistan, which I shan't go into now. If you would like to learn more about these and other issues and the other findings of the project, I encourage you to go to our website, www.carnegiecouncil.org. There's also wonderful material on the foreign policy website on related issues, fpa.org. You'll find at our website, for instance, our most recent panel's transcript. That included Joseph Stiglitz, Mary Robinson, Sakika Fukuda Parr, and other real leaders in democracy and human rights promotion. With that, let me turn to tonight's speakers. I'm going to introduce the second speaker first. Aryan Nair is going to be our second speaker. When it comes to mobilizing international norms and institutions to produce change, no one is more experienced than Arya. He has conducted investigations of human rights abuses in over 40 countries and has been deeply engaged for decades in the effort to strengthen international accountability. He was National Director of the American Civil Liberties Union. He founded Human Rights Watch and served as its executive director for 12 years. Since 1993, he has served as the president of the Open Society Institute and Soros Foundation's network. Indeed, he is credited by some with having got Mr. Soros into philanthropy in the first place. It is an indication of the power of this new force, the Open Society, in world affairs, that Edward Shevardnadze, the recently deposed president of Georgia, complained that the Open Society had orchestrated a quote-unquote democratic coup against him and had mastered this fine art by first deposing Milosevic in Yugoslavia. Arya is a man who stands on principle and yet clearly gets things done. And he is likely to be a wise guide on how to reduce the legal and democratic tensions produced by terror in our world. Our first speaker will be Richard Goldstone. Richard has just stepped down as a Justice of the Constitutional Court of South Africa, where he was centrally involved in developing and then applying the South African Constitution. Let me just say it's one of the most progressive in the world. From 1994 to 1996, he served as the chief prosecutor of the United Nations Criminal Tribunals for the former Yugoslavia and Rwanda. Sandra Day O'Connor, the US Supreme Court Justice, has said of Richard, and I quote, "The breadth of his personal experiences in South Africa and at The Hague provides unrivaled insight into the difficult choices that face emerging democracies in dealing with the crimes of a previous regime." But let me relay a very brief anecdote that tells you even more about the man. When leaders of an important law initiative approached Richard as prosecutor to ask him what they could do to help bring perpetrators to justice, he had one simple answer for them: help the defense. He was more concerned with having a fair trial than with having an overwhelming advantage for himself as prosecutor. We are lucky to have Richard visiting NYU and Fordham law schools this year, and we are lucky to have him here tonight to address us on promoting democracy through international law. Thank you.
Well, good evening, and thank you, Andy, for that generous introduction. I've been asked by our Master of Ceremonies and Director of tonight's program to address three questions. They all relate to the manner in which international law, and especially legal proceedings, can and should be used, firstly, to undermine authoritarian and semi-authoritarian rule, secondly, to strengthen democratic practices in countries in transition to democracy, and thirdly, to act as a deterrent to retrogressive action such as anti-democratic coups. So it's really a before, during, and after scenario. And let me begin by referring to my own country, South Africa. Our transition was, of course, remarkable. Transition from deep oppression of apartheid to democracy. And it was in no small part the result of the use and application of international law. From the end of the Second World War, the liberation movement, and especially the African National Congress, the prime liberation organization, became a major protagonist of human rights. It was part of an international and domestic human rights movement. The anti-apartheid movement was a human rights campaign. And for over 40 years, our black leaders certainly, and it wasn't only black leaders, but the members of the African National Congress, were part of a human rights culture. Their Bible was literally the Universal Declaration of Human Rights. They carried it around with them in their back pocket. And in 1956, they consulted their mass membership, and they produced the Freedom Charter, a remarkable document, in those days an avant-garde document, which reflected the aspirations of the organization and its many millions of supporters. And it reflected their commitment not only to a democratic form of government, but one that was non-racist and non-sexist. That human rights culture explains why our Constitution is one of the most progressive in the world. The majority party, the African National Congress, was committed to a Bill of Rights which would act as a brake on majoritarianism. Many in the black population objected and still object to their duly elected representatives being constrained by a Bill of Rights, and that there's a court of unelected 11 men and women who can say, no, you can't do that, even if 100% of you want to do it. That's what constitutional democracy is all about. The white majority, of course, became sudden converts to a Bill of Rights overnight, when they saw the writing on the wall and when they saw there was going to be black majority rule. They grabbed a Bill of Rights and became great human rights protagonists because they saw in a Bill of Rights the protection of their privileges that they'd acquired over 350 years. The policy of the African National Congress also explains why our Constitution now obliges our courts to consult international law and invites our judges in all our courts to consult foreign law. It obliges our courts in the interpretation of ambiguous legislation to prefer any reasonable interpretation consistent with international law over any interpretation inconsistent with international law. I think it's unique in having that rule applying to the interpretation of legislation. Our courts, and especially our Constitutional Court, have taken these provisions seriously, and our opinions reflect a wide use of comparative law and a respect for international law. These uses of international human rights law are unquestionably playing an important role in compelling compliance by public authorities with democratic processes. It's reflected in our administrative law, in our labour law, in all of the procedures that look into corruption in our society, and unfortunately there's still too much of that. And we have active NGOs, non-governmental organisations, that use the constitutional provisions, that use the Bill of Rights to hold our public officials to account. Let me say immediately that those NGOs exist to a large extent because of input from the United States. It was the United States government, it was the United States foundations in particular, that encouraged these human rights NGOs in our country. And American lawyers and judges engaged with lawyers, and particularly with judges in South Africa. I was one of the early beneficiaries of that, and it was a remarkable experience for me to be exposed to the internationalization of human rights at an Aspen Institute seminar for federal judges, at which I was invited in 1984. Until 9/11 of 2001, the United States, as Mary Robinson put it at a recent Carnegie Council high-level panel discussion, the United States was the standard bearer on civil and political rights. It was regrettably tardy in ratifying many international conventions, the Genocide Convention, many others, but it was the United States that took the lead in encouraging these human rights endeavours in my own country. From my own experience, I can assure you that without the push and without the human and financial resources from the United States, the Yugoslavia Tribunal and the Rwanda Tribunal would never have been established, and having been established, would never have succeeded. Many other South African judges have had a similar experience, and much of our work has been influenced by this engagement from the United States. And what's remarkable is our history would have led one to believe that that engagement would have come from English lawyers and English judges, but they gave up too early. They wrote us off as being beyond redemption and had little, if anything, to do with us. The South African Constitution requires our courts to test limitations of human rights against those found in other, and I quote, open and democratic societies based on human dignity, equality and freedom. That is a touchstone which our Constitution demands. More often than not, we looked first to the United States in this comparative exercise. I would suggest, however, it hasn't happened yet, but it might well, that the promulgation of the Patriot Act, the denial of habeas corpus to United States citizens, detention without trial of young boys and men on Guantanamo Bay now for over 2 years, that there will be a growing reluctance to turn to the United States for appropriate inspiration and guidance as an open and democratic society. The negative effect of these developments on emerging democracies is nothing short of tragic, I would suggest. As a report from the Lawyers' Committee for Human Rights recently demonstrated and documented, there's been an unfortunate knock-on effect in a number of countries resulting from this backward movement in this country. In Indonesia, one reads in that report, there's been talk of setting up their own Guantanamo Bay. In a number of countries, there are references to political opponents as being enemy combatants and denying journalists freedom of expression. Obviously, there's a tension between combating terrorism in the modern world and protecting civil liberties. But too many politicians right around the world, I would suggest, wish to be seen as doing something to combat terrorism without questioning too much whether what they're doing is really helpful in that regard. Fearful citizens are slow to oppose such measures, especially when their leaders tell them that doing so is unpatriotic and aiding the terrorists. So in the democracies, and especially in this one, this trend will only be reversed by a well-informed electorate, exercising its constitutional rights and making appropriate demands on its leaders. And there are the checks and balances in democracies, and especially perhaps in the United States. There are cases presently before the United States Supreme Court dealing with the jurisdiction of the United States courts over persons detained at Guantanamo Bay, and a second with regard to the rights of United States citizens to be detained by executive fiat and without any access to courts. There was the public outcry in this country that accompanied the first publication of the rules that were to apply to military commissions. There were protests. There was an outcry from the legal profession, from human rights organizations, and it didn't take too many months until March of 2002 that the rules were radically changed in direct response to public objection. That's the importance in a democracy of leaders having very frequently to pay regard to the views of their voters. And during the past week, pressure from Congress has moved the White House to set up a full investigation into the intelligence lapse that preceded the military action in Iraq. And Prime Minister Blair is being forced for that reason to follow suit in the United Kingdom. A fundamental norm of democracy is the rule of law. Andrew Cooper referred to it in his opening remarks. The rule of law is the assurance that leaders will be judged by the same laws that apply to all citizens, and that those laws will apply to the wealthy as well as to the poor, to the weak as well as the powerful. It is that same rule of law that is needed and so missed in the international community. Respect for international law is not possible when the wide perception is that it is intended to be a constraint on the activities of the poor nations and does not apply to the wealthy and the powerful nations. This perception, and it's a wide perception that's growing, is fed by the resistance of wealthy nations which resist being bound by international conventions. The most visible, but by no means the only example, is of course again the United States. Its opposition, for example, to the International Criminal Court, to the Kyoto Protocol on global warming, and the United States is now the only country in the world, the only member of the United Nations not to have ratified the International Convention on the Rights of the Child. These laws and institutions are thought by some powerful nations to be a good idea for the rest of the world, but not for them. They claim an entitlement to be treated exceptionally. We see selectivity in relation to Iraq. The United States, in its efforts to withdraw in the face of continuing violence, is keen to put off democratic elections. This is obviously rejected by the majority Shiites, who are assured by their majority in coming to power. It's feared by the minority Sunni. It does not still the demand for some form of independence from the Kurds. These are serious problems. But delaying democratic elections was also, I would remind you, the preference of South Africa's white leaders at the end of apartheid, not for dissimilar reasons. They saw that democratic elections would mean the end of white rule in South Africa, and the longer they could put that off, the better. If they had been allowed to do so, our transition negotiations would have gone on for a decade and more. But neither our black leaders nor the global community would allow that to happen. The result was that the first national election was a joyful celebration, and majority groups and minority groups have learned to discuss their differences and to participate in a vibrant debate in public legislatures around our country. The political violence that dominated the transition has all but disappeared. There appears in the last few weeks to have been really a very small resurgence of it, but that too has died down, even as we approach our third democratic election in April or May of this year. Decisions of our courts are carried out by the government, and the power of the Constitutional Court to set aside decisions of our President is respected. The challenge is educating future and present generations of South Africans to understand and embrace a culture of democracy. Not easy. It's expensive. We need adequate teachers, well-trained teachers, in order to do that. The challenge is educating South Africans to understand and appreciate their democratic rights and to ensure that they are used to bring benefits for all of our people within a reasonable time frame. It's not going to work if democracy doesn't really sift down to the ordinary people, men and women and children around the country. If democracy is to be encouraged in the Middle East, I would suggest that half measures are not sufficient. I do hope that the United Nations will become actively involved in the process and that every measure will be taken to enable free elections to be held sooner rather than later. Let me end by turning to the question of a trial of Saddam Hussein. The fact that the worst of Nazi war criminals were given a trial fair by the standards of the day was to the credit of the United States. Churchill had to be convinced by Truman that the Nazi leader should not simply be lined up against a wall and summarily executed. Stalin would have gone along with that. He'd been doing it for many years. Saddam Hussein is under the control of the United States, and it would be a huge setback to democracy in Iraq if he were to be handed over for a trial that is not judged fair by his millions of victims and by other nations in the region. And really the customers of such a trial, if I may put it that way, are the victims. That's the purpose of punishing criminals, is to bring acknowledgement and some satisfaction to the victims of criminality. There are some leaders in Iraq who want a speedy trial before Iraqi judges. One of the ministers said on the BBC programme recently that he wanted a swift trial, and the court should not be a platform for Saddam Hussein to give political speeches. The United States appears to be supporting the approach that he should be tried by courts set up by the present United States-appointed Iraqi Council. Whether appropriate judges can be found after 35 years of oppression in Iraq is not questioned by them, and it seems to me is open to doubt. Whether there are efficient prosecutors who will meticulously collect the evidence against Saddam Hussein seems to me to be open to doubt. I have no doubt that a fair and impartial trial will require the cooperation and input from the international community, and particularly from the United Nations. Its fairness will unquestionably be judged by the norms of international law. A fair trial of Saddam will have the effect of bringing acknowledgement to the millions of his victims and elsewhere in the region. It will enable those victims to begin their healing process and to become full participants in their own democracy. It will also have the effect of demonstrating that the evil regime was that of a criminal clique and not one representing all of the people of Iraq or even that of the minority Sunni or any other group of people. I know of no better way to avoid belief in collective guilt that can poison the path to democracy. In South Africa, I have no doubt that the work of the Truth and Reconciliation Commission has helped to avert collective guilt on the part of many in the white community. The demonstration of individual criminal behaviour through the evidence of more than 21,000 victims who gave evidence to the Truth Commission, of more than 7,000 perpetrators who claimed amnesty, has enabled many in the white community to join their black compatriots in building a decent, non-racial society. The crimes perpetrated by the regime of Saddam Hussein cry out for a fair and impartial criminal process. A Truth and Reconciliation Commission might come later, but there must be appropriate punishment for the leaders in light of crimes of this magnitude, genocide and crimes against humanity. May I end with a note of caution. In South Africa, the institutions of democracy were present prior to transformation. There was a working democracy for the white minority, from which the black majority was totally excluded. Notwithstanding that exclusion, the institutions were there for the new majority to take over and use. If anything, they are being used more efficiently and more purposefully than had been the case during apartheid. In Iraq, the institutions of democracy will have to be built from the ground up. That is a daunting prospect, and one which does not appear to have been fully appreciated by the present administration. In all of these endeavours, the people of Iraq are not going to succeed without the fullest international assistance. Neither elections nor trials can be held in an atmosphere of fear and violence. Adequate policing will be essential for those processes to take place. Having intervened with military force, having rid Iraq of the government of Saddam Hussein, I would suggest that the United States and its coalition partners have no option but to stay the course. They and the United Nations should not leave Iraq until the Iraqi people have been given the opportunity of fashioning their own democratic constitution and institutions. If that can be accomplished, and only if that can be accomplished, will the prospects for lasting peace and the prevention of anti-democratic coups be substantially increased. Thank you.
Thank you very much. It's a great pleasure to be here, and it's an honor to appear on the same platform with Richard Goldstone, because I think that probably no one has managed to symbolize a commitment to international law more effectively than Richard Goldstone. I believe that such institutions as we have to promote compliance with international law were made effective by Richard Goldstone, and